Can you hear me?
I can. Sir, are you David Showalter?
I am David Showalter.
All right. Ms. Showalter, if you're there, I'm not able to see you.
I don't know if you can hear me.
Yeah, can you turn on your camera, please?
Trying. Start video.
Go into the settings,
You have it all jacked up.
computer settings. Type in camera.
What have you done? I'm supposed to be.
Let's turn it on. It's on. Okay, it's on. Should be able to get to the.
Okay, let's see.
All
I have
right, if
no
you're
idea.
having trouble, we can just go forward. I can hear you okay, so that's fine. We'll just we'll
Yeah, I
proceed.
can't figure out how to turn it on.
All right, is
My
this Dorothy Showalter?
Yes, sir.
Okay. All right, we're on the record in Showalter versus Showalter. This is file number 2511986. The record should reflect both parties are connected by Zoom. This is set today. It looks like the parties have submitted a proposed judgment of divorce and have signed that. Ms. Showalter, did you want to move forward with finalizing your divorce today?
Yes.
Mr. Showalter, is that how you wanted to proceed as well?
No,
No? Okay, why not?
I think we still have something worth fighting for.
All right, well, in Michigan, both parties don't have to consent to a divorce as long as one party wants it. The court has to proceed. So that cannot be a reason why we can't go forward today. And I note that you did sign the judgment back in September, is that right?
That is correct.
Okay. All right. Do you have any other reason other than you don't want to get divorced?
No,
Okay. All right, then, Ms. Showalter, I'm going to place you under oath. I'm going to ask you some questions. The questions that I'm going to ask you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Because I can't see you, I'm going to ask you to raise your right hand and tell me once it's raised.
It's raised.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Showalter, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant? Ms. Showalter,
Yes, sir.
are you currently pregnant?
No.
Okay. Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Correct.
This proposed judgment indicates that you have already divided up any assets or debts of the marriage and that you don't own any real property with Mr. Showalter. Is that correct?
That is correct.
All right, and you're asking to have your last name changed to Sly, S-L-Y, is that correct?
Yes.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the plaintiff. Mr. Showalter, can you raise your right hand for me, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Showalter, did you hear all the questions that I asked Ms. Showalter?
Yes.
Did you hear all of her answers?
Yes.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
Okay. All right. The court will grant the divorce. I've signed the judgment with today's date. That means the divorce is final as of today. Ms. Showalter, what that means is that your name is legally changed. So you're going to need to make sure you get a copy of this judgment from the clerk's office here in Grayling, because you'll need that to change your identification and other documents. Do you have any questions?
No, sir.
Mr. Showalter, did you have any questions?
No.
Okay. All right, thank you. That's all for this hearing today, and all parties are free to disconnect at this time. Thank you, Martin. All right, ma'am, are you Andrea Martin? Oops, I need you to unmute, please.
Can you hear me now, Your Honor?
I can, yes,
Yeah.
thank you.
I am Andrea Martin.
Okay. This is Martin versus Sangwan, file number 2512001. The record should reflect that Ms. Martin is present here by Zoom video today. Ms. Martin, I have this set for entry of a default judgment of divorce today. Is that how you wanted to proceed?
Correct.
Okay. I'm going to place you under oath. I've got some questions that I need to ask you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. If you would
Yes.
raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Yeah. Okay, sorry about that, Ms. Martin. Ms. Martin, my first question, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Correct.
At the time you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Correct.
Had you been a resident of Crawford County for at least 10 days?
Correct.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Correct.
Does that remain true today?
Yes, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No, Your Honor.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor.
The judgment also indicates that you don't own any real property with the defendant. Is that correct?
Yes, Your Honor.
And that all debts and other personal property have been divided up between the two of you, is that correct?
Yes, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Martin. I reviewed the file prior to today's hearing. It does appear that the defendant was properly served with the summons and complaint. The defendant failed to answer or otherwise defend. The defendant was defaulted. The defendant was provided with notice of the date and time of today's hearing, which was 1:30. It's now 1:47. Defendant has not appeared either remotely or here in the courtroom in person, so the court finds it would be appropriate to enter the default judgment of divorce. I've signed that judgment, so Ms. Martin, that means that your divorce is final as of today.
Thank you, Your Honor.
Did you have any questions?
No, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay, we've got everybody connected for the 1:45 hearing. This is Ronald Langer versus Secretary of State, file number 2511932. If I could have counsel put your appearances on pause.
Crawford County Prosecutor Sierra Koch.
Thank you, Your Honor. Jason Thompson, representing the petitioner, Ronald Langer.
All right, thank you. Mr. Thompson, I did receive your brief along with all the supporting documentation that was submitted. I had a chance to review all of those materials, including the ruling of the hearing officer, most recent one, the one before that, all the materials that were contained and attached as exhibits to those hearings. I also received a copy of the transcript. I had a chance to read through that. So I have all that information. Ms. Koch, I did not receive any kind of written brief from your side. Are you, or what is the position of the people with regard to the petition?
The Secretary of State's office did not do a response. We cover these hearings for them. They provided a statement believing that this court has jurisdiction and that they wished that the order from the hearing officer be upheld. Having read through that order, it looks like his feelings were that, overall that he didn't meet the requirements, and essentially they didn't like the letters. The evaluation wasn't good enough. But I think the real issue is that he had it previously, and he screwed it up. So I would defer to the court whether or not if we have Mr. Langer, this court's already read all of this, so I don't need to repeat any of it, has met his burden or not. Thank you.
All right, thank you. Mr. Thompson, as you're aware, the court can't take any type of evidence here today. The court has to rely on the record before the hearing officer, but did you have any oral argument you wish to make?
By argument, Your Honor, obviously Mr. Langer isn't subject to any kind of lifetime ban because of what happened in 2019. He had a .04. He pled to that. He served his time for that. We believe that the factual record does establish that he is sober and that he's been continuous sobriety. We think the hearing officer was unfair and unfairly limiting in refusing to consider the letters that were submitted in good faith and was openly hostile to Mr. Langer and his testimony. We would just want to remind the court that what we're asking for here is an interlock license. So Mr. Langer would be monitored at a higher level than any other citizen while he drives. He would have to continuously blow clean. He would have to provide clean blows to operate that motor vehicle, and we think that would sufficiently protect the public safety. Mr. Langer is not a drinker. He has a background, and the court's familiar with his record, but I think the testimony at the hearing clearly, establishes that he is a candidate for the wildlife. Sounds like a class. Thank you.
All right, thank you. Again, I did review all of the materials. First of all, with regard to the standard, the court, this is not a de novo review as the attorneys are aware, and the court is not in a position to make its own decision or to arrive at its own conclusions in this case. Even if I would have come to a different result than the hearing officer, under the standard of review, I'm not to substitute my own judgment. The court is merely to review the hearing officer's determination under a number of different factors. The challenge factors here are that that decision was not supported by competent material and substantial evidence on the whole record, and that it was arbitrary, capricious, or an abuse of discretion. So the court standard of review is to determine whether or not it is supported by evidence and that it is not an abuse of discretion. And that is a relatively low standard and accords a fair degree of deference to the hearing officer's decision as the one who heard the live testimony, had an opportunity to make credibility determinations and so forth, which I don't have the benefit of. So that's the standard that the court's looking at. In terms of the hearing officer's decision, in my view, the hearing officer's determination was made based on essentially two deficiencies in the petitioner's case. Number one, with regard to the substance abuse evaluation, the hearing officer felt that the testimony that was given was inconsistent and or lacking certain details compared to the information that was given to the substance abuse evaluator, and in particular things such as his prior conviction history. And so the hearing officer made the determination that because the information given to the evaluator was at the very least inconsistent, perhaps not accurate, that undermined the evidentiary value and the probative value of that evaluator's decision and prevented the hearing officer from being able to determine that the petitioner had met his burden of producing clear and convincing evidence that his abuse or substance dependency was under control and likely to remain under control. The second basis that the hearing officer offered was that the support letters that were submitted, the testimonial letters, did not contain sufficient detailed information about Mr. Langer's underlying substance abuse. And so for those reasons, the hearing officer determined that he had not met his burden. I had an opportunity to review both the testimonial letters that were submitted as well as the evaluation. And again, I did review the testimony by transcript. The court finds that there is a basis for the hearing officer to have concluded that there were at the very least inaccurate or incomplete facts, and that there were inconsistencies in terms of Mr. Langer's testimony versus what he had previously reported and what his driving record reflected. I also reviewed the testimonial letters, and again, it's sort of a judgment call. The hearing officers are looking for very particular information under the standards that they're defined. I can't say that those letters were, or that the hearing officer's determination was so outside the scope and that he didn't have, an arguable point with regard to the content of those letters. So again, it really comes down to this court's review. It doesn't matter whether I would have made a different decision if I was the hearing officer. Again, I find that the hearing officer did base his decision on evidence of inconsistencies within the record, and that the hearing officer, his determination with regard to the content of those letters was not so far off that the court could find that it was an abuse of discretion or that it was arbitrary or capricious. Otherwise, the court finds that the hearing officer cited the correct statute and regulation, that he accurately applied the law in this case. So for those reasons, the court finds it does not have a basis to overturn the ruling of the hearing officer. So the court is going to deny the petition, and Mr. Thompson, if you would prepare an order that reflects the ruling of the court today, in case Mr. Langer wants to pursue further appellate relief.
Okay,
All right, thank you. That's all for this hearing today. All parties are free to disconnect at this time. Okay, let's see. We will go on the record now in Morgan Wells versus Morgan Wells. This is file number 2512000. Looks like we have both parties connected by Zoom video. This was set for a pretrial hearing today. I did speak with our clerk, Sarah, who indicated, I'll ask you first, Max Morgan Wells. She indicated that the two of you had gone to mediation and reached an agreement, but that needed to be reduced to writing, and then we could go forward with finalizing things. Is that your view of how we're?
Yeah, that's what we agreed on, yeah.
Okay, and Brian, is that your view of it as well?
Absolutely.
Okay, so I'm going to set this for a final hearing date. I'll send you both notice of the date and time of today's hearing by mail, just like you got for today. Or notice of the date and time of that next hearing, the same way you got notice of the hearing for today. The only thing that I will need you to file along with your mediation agreement is a form called a judgment of divorce. And Max, are you the party that actually filed for the divorce in this case?
Yes, I am.
Okay,
Yep.
so you can find that form, that judgment form, in the same place that you got your form to file for divorce.
Yeah, I got them all together.
Okay, so you just need to fill that out, submit that to the clerk prior to that next hearing, as long as I have that judgment, because that's what I have to sign. That's the final thing that gets signed to finalize things. So as long as I have that, then we can finalize things at that next hearing. Max, do you have any questions?
I was kind of a little hesitant about having him unblocked on Facebook. I was wondering if I could possibly get that switched over to maybe him calling the store and letting me know then when he gets the paperwork so we can sign over the deed to the house
Quick claim.
or quickly, yeah.
So I don't know, is there a personal protection order in place or something?
No, nothing like that. But I just don't feel comfortable doing that quite yet. Unblocking him on Facebook.
The only way that I can order Brian to have some particular kind of contact or not have contact with you is through a personal protection order. I can't just off the cuff say you can't do this. I don't have jurisdiction to do that.
Okay.
So
all right. Yeah, no worries. I was just wondering.
Unless there was a way the court can already draw up the quick claim deed, releasing them and have that all the time that we sign. But like I said, I just want to be able to have a way of contact him besides through a friend of a friend or through a third party to say, hey, let's meet this day at Huntington Bake this way without our phone numbers exchanging. I thought with on Facebook, if you just unblock me for the month of January, just that month of January, I don't care about Facebook itself, just on Messenger, so have some way of being able to contact, or if he would, I need some way of contact to say when we can meet up. I don't want to go through a third party if I didn't have to. I don't want to involve other people.
all right, so here's where I'm at as a judge, okay? I don't have any legal basis to prevent either of you from having any kind of contact from the other in any way. There aren't any orders that prohibit either of you legally from contacting each other in any way. So that's totally up to you to how you want to communicate. At this point, there's nothing legally preventing either of you from contacting the other one in any way at all. So.
Okay.
Yeah.
All right,
Or
thank you.
I can just tell somebody to message him and tell him to message me for that moment. He can unblock me and message me. We can make the connection then. And then once we make the, everything finalized, and he can go back to blocking me. That's fine.
Yeah, I mean, again, this isn't something that I'm involved in. I
Right,
this isn't
right.
a legal matter at this point, so.
Completely
I'm
understand, yeah.
not gonna tell
I,
anybody what they can or can't do, so I'm gonna, this is something between the two of you at this point. This isn't really something that needs to be in front of the court or on the record.
Okay.
So I'm going to move on. Please look for the notice of the date and time of that final hearing. Please submit the final judgment of divorce prior to that. And we will be all set. Thank you. You're both free to disconnect.
Thank you so much.
thank you, sir.
Mr. Thompson, your office is signed in here. You know,
We're observing this hearing, but we're not parties.
okay,
This involves a criminal client related to a case, but we're not involved.
all right, sir, is your name William Kroll?
Yes, Your Honor.
Okay. 1 second. Okay, we're on the record in Pajolo versus Kroll. This is file number 2512012. Record should reflect Mr. Kroll is present today by video from the Crawford County Jail. Miss Pajolo is not present. This is set for a hearing today. Mr. Kroll, you filed a motion to terminate the personal protection order in this case. Is that correct?
Motion to modify or terminate, Your Honor.
Okay, what are you asking the court to do?
I would like to terminate it because she was apparently forced to file it in the first place to get her child back.
Okay,
And she would be willing to fully drop that, Your Honor.
Okay, well, she's not here to say
Because she's got a lot of court appointments, me too. So me and her just talked yesterday and she was totally unaware of this court date being today. She thought it was next week or tomorrow or something.
All right, well, I also have information that you were arrested for home invasion, violating your bond and violating this PPO. Is that true?
Yes, sir.
Okay, so she's not here to tell me she wants this dropped. You're telling me that's what she wants, but you've also been arrested
Right.
for
Yeah.
home
Well,
charge.
right now is probably not a good time to modify it or terminate it. Maybe modify, but you know, I'm still in jail, so it doesn't make a difference. So we're gonna probably just need to reschedule, to be fair.
Yeah,
Or I don't know, maybe get her to come in and talk to you.
Yeah, I would completely agree with you on that. So what I'm gonna do is, I'm not gonna make a ruling today. I'm gonna adjourn this without date.
Okay.
I will give you an opportunity to refile this motion. So call the court, ask for a separate date. I'll give you another date and then we'll see where we go from there.
Okay, yes, sir. I question how long do I have to do that? Because I know we're past the 14 days. I just got myself 15 days in here. So how long do I have to file that?
So you filed your original motion within the time frame. I'm extending that time frame based on the circumstances.
Okay.
And so I'll give you 30 days to refile that.
All right, thank you, sir.
Okay. All right, that's all for today then. The court's going to disconnect at this time.
Hello.
Yeah, sideways.
Good afternoon, Your Honor.
All right, hello. We'll go on the record now in Gens versus Smith. This is file number 25-11839. If I can have counsel put your appearances on.
Afternoon, Your Honor. Ivan Pappas on behalf of the plaintiff.
Scott Isles on behalf of the plaintiff.
Sorry, I didn't see him. Dan LaBella on behalf of the defendant.
I don't know why my camera's not working. I'm trying to get it to pan over so that you guys, Mr. Isles is present here in the courtroom. Having some technical difficulties. All right, we're on the record in this file today for purposes of a motion to compel Mr. Lobello. I did receive notice that at least some matters or issues contained within your motion have been resolved. Is that correct?
Your Honor, it's actually the plaintiff's motion to compel the deposition of Mr. McDonald.
We have motion hearings on the 8th, Your Honor, of January. That's what those filings are regarding.
That's right, Your Honor. Today is just the,
I thought we had a motion to compel for today.
We do. That would be Mr. Pappas would address that.
This is plaintiff's motion to compel.
Yes.
Defendants is set for January.
Right.
Okay. All right. Sorry about that.
but in that
I see.
vein, Your
All
Honor,
right. So Mr. Pappas, tell me what you're asking the court to compel a deposition of Gary McDonald. Is that correct?
yes, Your Honor, this is defendant's sole accident reconstructionist. We had the dep scheduled for November 6th. Defense counsel reached out on October 30th and canceled the dep, stating that they'd give us additional dates, that there's no objection to the dep. We've made efforts to obtain additional dates for this deposition with no success. Numerous emails that were laid out in the motion. I won't bore you with those dates. I don't believe that there's any objection to the deposition taking place from defense, Your Honor, but all we're asking for is to have a date certain and that the court order that this dep does go forward. So that's what we're here for today.
Okay, Mr. Lobello, I didn't get a written response. What's your position on this?
And Your Honor, I just learned from Mr. Isles today that the motion was going. Apparently, it was sent by email. My email was incorrect in the response. However, Mr. Carbajal at my office also received it, did not inform me that he received it. So that's why I did not provide a response, Your Honor. But I did have the chance to speak with Mr. Pappas on this. I just informed him that, I've been in touch with Mr. McDonald for dates to see if he either adjourn the motion today and see if we could sort it out. I would have otherwise tried to sort it out with him prior to today, but again, I just learned of it at about 8 a.m. this morning. So I have no problem with providing Mr. McDonald for deposition. I'm in the process of trying to get dates from him. And it's just as far as a timeline, Mr. Pappas and I were trying to discuss, a timeline for providing that. I think given the upcoming holidays, that early January is probably going to be the earliest. So if the court was to order that we provide dates for Mr. McDonald's deposition sometime in January, I think that's entirely doable, and I think that I can get hold of Mr. McDonald within that time, Your Honor.
Okay, Mr. Pappas?
Your Honor, I think that's reasonable. I would just ask the court for an order stating that the deposition will take place by a date in January, because it has been since very late October that we've been trying to get these dates, and I hate to bother the court with this type of motion, but I think we do need a date certain, or at least an order stating that the deposition is to take place by January 15th or January 21st, whatever the court thinks is most reasonable. I know the holidays are coming up.
All right, so the court will grant the motion. The court will order that the deposition of Mr. McDonald take place. I'm going to say that Mr. McDonald has to make himself available for deposition within 60 days of today's date. So that takes us past the holidays and gives a little bit of wiggle room throughout the month of January there. So Mr. Pappas, if you can prepare an order that reflects that ruling and submit that to the court, either with the stipulation as to form for Mr. Lobello or under the 7-day rule.
Understood. Thank you, Your Honor. Appreciate your time today. Thank you very much, Your Honor.
Pappas or Mr. Isles, anything else for today?
No, thanks, guys.
Thank you, Your Honor.
Okay. Thank you. You're all free to disconnect at this time. All right, Mr. Schumacher, are you able to hear me okay?
I hear you well, Judge. Thank you.
Okay, 1 second here. Some other parties connecting in. Ma'am, are you Kristen Wilson? Sorry, you're muted. That's a.
Can you hear me now?
I can, thank you. Are you
Yes,
Ms.
I'm
Wilson?
Kristen. Yes.
Oh. All right, we have another individual connected here, whoever that is, if you can unmute.
Can you hear me?
I can, thank you. Are you Mr. Wilson?
Yes, sir.
Okay, all right, we're on the record now in Wilson versus Wilson. This is file number 2110869. The record should reflect both the parties are present by Zoom. Mr. Schumacher, you're appearing on behalf of Ms. Wilson, is that correct?
That is correct.
Okay, we're on the record here today because Mr. Schumacher, your client, is alleging that Mr. Wilson has not cooperated with the process of having the spousal support administered through the friend of the court. Is that your position?
That's correct, Your Honor.
Okay, is there anything further you wanted to say with regard to your motion?
No, other than that, we sent him a letter, sent Mr. Wilson a letter on September 30th. I called him before that. I have no cooperation. So we're forced to ask for attorney's fees and cooperation with the friend of the court hearing. Or
Okay, Mr.
stipulation.
Wilson. All right, thank you. Mr. Wilson, what's your side of this?
I never received a call from him. I did receive a letter, but so the reason that I haven't done the friend of the court is what I had planned on doing is in 2 months, I'll be at the age where I can access my retirement without the early withdrawal penalty. And I just plan on paying her off what I owe her and the rest of the spousal support in one lump sum.
Okay,
I mean, I've been making my payments all along, so I'd have to do that for 2 more months and then I can just pay her off for the remainder of the spousal support and just avoid the friend of the court altogether.
Okay, Mr. Schumacher, do you have any response to that?
Well, my response is, it's the first I've heard of it. I'd have to discuss it with my client. If she's agreeable, of course, I'd ask for attorney's fees for getting this far. We don't hear from Mr. Wilson, so that's the result of what happens.
Okay. All right. Well, I guess where we're at right now, Mr. Wilson, you and Mr. You're free to talk to Mr. Schumacher and to see if you guys could come up with some kind of alternate arrangement outside of the court hearing today. But you know, the court ordered, I think this was back in April, that the parties were to proceed through the friend of the court. And Mr. Wilson, I mean, what you're saying doesn't seem like an unreasonable plan to me. And I get the logic of why you want to do that. The problem is that, you know, when there's a court order in place, you can't just make your own decision about what you want to do and when. Ms. Wilson has now had to incur attorney fees to bring this motion and have this hearing today, whereas if we had had some communication prior to this, we could have avoided this whole thing. So, Mr. Schumacher, I'm not hearing any basis from Mr. Wilson other than that it's his preference. So there's no reason why the court should not grant the motion. So the court will grant your motion. I will grant you attorney fees for preparing the motion in your appearance here in court today. So if you can submit that bill of costs to the court along with your order.
Okay,
And to the extent, Mr. Wilson, that you want to come to some other arrangement, I would encourage you to get in touch with Mr. Schumar to see if you guys can negotiate something between the two of you.
Okay,
All right, that's all for this hearing today. Mr. Schumar, if you can submit that order under the 7-day rule, please.
thank you. Will do.
Okay. Thank you. All parties are free to disconnect at this time.
Thank you, Your Honor.
All right, that concludes our court's afternoon docket. The court will be in recess.